So, Councilor Buzzard, would you bless the meeting?
Dear Heavenly Father, we ask you to keep your hand upon our citizens today, keep your hand upon our tribal council members as we discuss the business of the Cherokee Nation. We also ask you to give us safe traveling graces as we go to our homes. We ask you to keep your hands upon our troops that serve here in the United States and those that serve abroad. We also ask you to remember us for this Thanksgiving holidays that are coming up, and to give thanks to the Christ Savior that come into our lives to make it better for all of us that are involved. And today he asks you to keep your hand upon our citizens to make decisions for the nations. And we ask all of this in Christ's name. Amen.
Amen. Roll call, Shelley.
Yes, sir. Joe Bird.
Ani.
Brandon Duncan.
Aye.
Keith Austin.
Here.
Tommy Buzzard.
Here.
Julia Coates.
Here.
Sean Crittenden.
Aye.
Joe Deere.
Aye.
Mike Dobbins. Rex Jordan.
Here.
Darrell Legg.
Here.
Weston O'Fire.
Aye.
Laura Patzkowski.
Here.
Mike Shambaugh.
Here.
Mary Bakershaw.
Aye.
E.O. Smith. Janice Taylor.
Here.
Victoria Vasquez.
Aye.
We have four.
Okay, the minutes were mailed to you at this time. I entertain a motion to approve.
So moved.
Second.
Motion and a second. All in favor signify by saying aye. Aye. All opposed. Reports, Marshal Shannon Buell or his designee.
Morning, everyone. I'm Scott Craig. I'm one of Shannon's captains. Shannon's on travel this week, and he asked me to come and visit with you and see if there were any questions that I could help with.
What kind of activity have we been doing here in the last 30 days?
Well, everything I think is in the report, and we still have one in Artesia, New Mexico, in the federal law enforcement training. It's Kyle Shambaugh. He graduates on December 18th, and he's doing really well in the academy. We've had just our standard reports and everything else that's been going on.
Any questions for our marshal? We just appreciate you guys, what you do for us as a tribe, and making sure that we're in good hands. Thank you.
Thank you very much.
Okay. Office of Attorney General, Chrissy Nemo. I know you've been busy.
Well, it's only been 2 weeks since I've been here, but we have had updates on everything I talked to you about last time. We've been a busy couple of weeks. The ICWA case in the Fifth Circuit, the plaintiffs in that case filed for rehearing en banc, and that was granted. So the entire panel of the Fifth Circuit will hear that case the week of January 20th. The court doesn't say why they're rehearing it, just that there was a poll and the majority of the judges wanted to rehear it, but it's a little bit concerning for us because the panel opinion was very strong. There was a dissent on one issue that hasn't kind of been a central argument. So it is, I think, surprising and somewhat concerning to us that they are going to rehear that case. We will continue. Cherokee Nation, along with 4 other tribes, have intervened, and the federal government is also a defendant in that case, and so far they have been very strong on their position of defending the constitutionality of ICWA, and we don't have any indication that they're changing their position. So we will wait and see on this. We'll have argument in January. My guess is it'll probably be at least a couple of months. The lower court decision finding that ICWA was unconstitutional is still stayed pending the outcome of this. So even though they're rehearing the case, there's no immediate impact to the specific cases involved that led to that, or any other ICWA cases. But you will likely see increased media coverage on this case in the coming months.
What state will it be reheard?
It's the Fifth Circuit, and that is in New Orleans, is where the court is located, and it will be the, I will get you, I don't know the total number of judges,
Okay,
but it's
that's
in
okay.
the teens that will sit with the entire court hearing that case. We were notified last Friday that the 10th Circuit denied our petition for rehearing en banc in the UKB Land into Trust case. The mandate has not issued yet on that case, and we continue to look at what our next steps may be. The council would be notified prior to any petition for cert being filed in that case. The opioid case, although there hasn't been any official action, there was a meeting last Wednesday, I believe, and they are closed-door meetings, but they transcripts are published, and it's attorneys representing all of the plaintiffs in the multi-district litigation. So it's attorneys for states, cities, counties, and tribes. And that judge is looking at sending several cases back to the federal district courts. This is all in Cleveland, Ohio, and they've combined all the opioid cases there. The federal judge is looking at sending a handful of cases back to the federal district courts where they originated, and they're looking at a state case, a city case, a county case, and a tribal case. And Cherokee Nation, by agreement of other tribes involved in that multi-district litigation, is at the top of the list of cases to be remanded to. In our case, it would be the Eastern District, which is Muskogee. So I believe that there is expected to be a ruling on that by the end of this week. So we may know by the end of this week whether or not our opioid case is being sent back here to attempt to go forward with trial. And that would be really big news for us. Finally, I reported to you last time that the AG's office had attended the meeting with Mike Hunter accompanying the chief. What I didn't say, because it hadn't been publicly announced, that the state proposed arbitration to the tribes, and this has now been reported. There's a Tulsa World article about it. The tribes, in a unified voice, as they have so far, responded to the state and said that arbitration is not the right step at this time, and that they await further proposals from the state on gaming compact discussion and negotiation. So they proposed arbitration for the issue of whether or not the compacts renew, and the tribes restated their position that they believe that the compacts automatically renew, and if the state wishes to negotiate the things that can be negotiated under automatic renewal, that the state should share their proposal on that. So that is all of the updates I have, and I'll take any questions that anyone has.
You've been busy. Any questions? Yes, Councilor Christie.
Chrissy, on the UKB issue, so this is the second time that they've ruled in favor of the UKB?
So this ruling was not a ruling on the merits. It was just a decision. The original decision was by the 3-panel judges. We ask that all of the judges rehear or look at the case.
This past time?
Yes, so this was a denial of en banc, meaning that they denied our request for all of the judges to look at the case. So it wasn't a decision on the merits. It was just a denial of all of the judges hearing it.
How close was that?
I believe that the order said that no judge requested it, but I don't know that that means, we don't know the vote. It's denied, and there's the way they do it is they take a poll of the judges, and if any of them want to rehear the case, then they can have briefing on why they should or should not rehear it, if that makes sense. They don't tell you that this was a 10-7 vote or this was a 17-0 vote on whether or not to rehear, just that no, in the poll, no judges requested rehearing.
I just, I'm no judge, I'm no lawyer, but I am a resident of Adair County, and I live there, got friends and family there, and this, in my estimate, in my seat, may be a good chance to do that, but that's me, my thinking, it's been consistent, that's my beliefs, and I just wanted to share that with you. Thank you.
Councilor Taylor.
When they do a panel, when a case is going to be heard by just a panel, how do they assign who sits on that panel? Can you walk me through the process of that?
I believe for the most part, it is random. I think the chief judge in that circuit may have some input on whether or not they are on a specific case, but outside of that, I think it is and some of it depending on scheduling, some of it also depending on where that judge originates from, because, for example, in the 10th Circuit, there are 5 states, and typically how they get to the circuit court is they have been district court judges, and they are then appointed by the president, confirmed by the Senate, to be a circuit court judge, although that's not always the case. So they also look at whether or not that judge, if that case is originating from the state of Oklahoma, typically not on those, because to avoid conflicts and that type of thing. But I think those are minor considerations, and I think overall that it is fairly random.
Okay. And then my second question was back to the opioid case. So it's my understanding that those cases were all lumped together. The proposal to send us back here, does that mean our case will be tried individually?
Yes, it would be, if it is remanded, our Cherokee Nation case we have against 6 defendants, 3 distributors, 3 pharmacies, would go back to the Eastern District and, presumably go to a jury trial.
And it would be tried on its own merits as to the Cherokee Nation
Yes.
rather than this?
Yes.
Okay, thank you. That's all I have.
Good question. Anybody else? Yes, Councilor Nufar.
On the UKB case, what are our options now that it was denied? And what is the position the AG is recommending that we take?
The only, legal option in the case is to seek cert from the Supreme Court. The 10th Circuit, that's the next level of appeal.
Right.
And I think that there are considerations ongoing, but that is the only legal option in this case going forward.
Okay. It seems like we've been to the Supreme Court several times in recent years. Have we had some success there on our appeals to the Supreme Court? Is there?
We have only been on the adoptive couple case recently, in the last, I would say, decade at least. Indian country cases in general go up, and we sometimes either join or support those as amicus efforts. We've had the last 2 years have been pretty good for tribes. Outside of that, the win rate for tribes is always less than 50% at the Supreme Court. This case, I think, is you can't kind of lump it into those Indian law cases because it's 2 tribes, and I don't have any guesses at what the outcome may be.
Right, appreciate it.
You're always rolling the dice with the Supreme Court.
Well, and they don't. So just to clarify, every other appeal is as of right. So district court rules, everyone can appeal to the 10th Circuit, and they have to at least issue an order on it. The Supreme Court only takes the cases that they choose to take. So we are not, if we file a petition for certiorari, we are not technically appealing. We are asking the court to take the appeal, and they can either take it and rule on it, or they can deny cert, and then the 10th Circuit decision stands. It's the only court that you don't have an appeal as of right to.
It's kind of amazing. I've listened to some of the arguments in the Supreme Court, and to listen to the Supreme Court judges, the United States is smartest that apparently we have the lack of understanding of tribal law. It's kind of amazing to listen to some of those, but that's just a comment I wanted to make on that.
I agree.
Yeah, the last one was Dollar General. And we came out okay on that one.
Right.
Because,
Luck.
well, one of the Supreme Court just happened to pass on.
Yeah.
And that was a deciding vote, Scalia. I watched that one. That was interesting.
Right. Scalia voted for us in the Veronica case. That was a weird split in that case because it was a 5-4, and the 4 that ruled in favor of tribal interest was Scalia and the 4 women on the court, which is an odd 5-4 split for them. So he, at least on the ICWA issue, he sided with the tribes.
Yeah, rolling the dice. Stay away from them if you can.
I agree.
Yes, Counselor Buzzard.
Chrissy, just on a different subject here, and I should have brought it up maybe in the health department, but as you know, the ongoing case about the Roundup lawsuit, have you had any discussions about that? Because the reason I bring it up, over in Adair County several years ago, we had some tribal members saying there's a lot of cancer up and down these power lines, and you know, the power lines go in the spray, and they use a lot of Roundup. And I'm just wondering, has it been approached, have any to look into anything like that? And I didn't ask the health department people about any of that stuff.
I have not, I have generally heard about the Monsanto Roundup
Yeah.
cases. I do not know of us in any way being involved in those, but it's something that we can definitely look into.
Well, it's just, you know, it's just a lot of our native people work with that type of work and pesticides, and I just think we need to look out for some of our native citizens and at least let them know that those options are out there, because I know people where I come from, they do a lot of that type of work, and I don't think they're really aware of those things that's happening. But I remember several years ago working here and being on the council where we had a lot of concerns about cancer down in some of our counties here. So I just wonder if anybody's approached.
Well, what I can do, and I don't know enough about those cases. I don't know if they're being brought by individuals or by municipalities, if they're multi-district like the opioid is, but we can get some information to the council on kind of the posture of those cases, whether any of them have settled, what the judgments have been, just to
Well, I just think
get some information.
Yeah, we need to get the word out to our citizens, because there is a lot of cancer within our citizenry. So anyway, I just wanted to see if you had approached that. Anyway,
we will follow up.
Thank you. Thank you, sir.
Good question. Anybody else? Yes, Counselor Shambaugh.
Will you be available here shortly?
Yes, sir.
I'd like to talk to you.
Okay.
Keep up the good work.
Thank you.
Appreciate you. Okay, Gwen Terrapin.
Good morning. So far, there haven't been any changes to our requests. We've still got 37. None of them are outstanding at this time, and everyone should have received a copy of my report.
Any questions for Gwen? You do have the report. Good report. Thank you.
Thank you.
Tax Commission, Sharon Swepston.
Morning.
Morning.
I believe that you have my report. I'll try to address any questions that you might have.
I had a couple tribal members tell me, I didn't know very well, they just approached me about the tag office, and they said, you guys are the most accommodating group of people that they've been around.
That's good to hear.
They said, you guys just go above and beyond what you're supposed to be doing. They're very pleased. And I didn't really know them.
Well, I appreciate that.
That's good when you hear something.
It is. I'll pass that along to the staff because it's important to them to know. So,
Anybody else? Yes, Counselor Critton.
Hey, good lady, how's them numbers coming?
good. I should have something together for you here for too long.
Appreciate you. Thank you.
Anybody else? Okay, good report.
Thank you.
Gaming Commission, Janice Purcell.
Thank you. Good morning.
Morning, Janice.
I previously submitted my report. Does anyone have any questions on it?
Any questions for Janice? Yes, report stands on its own. Thank you.
Thank you.
Human Resources, Mr. Nathan Morton.
Good morning.
Morning.
Not much new in the 2 weeks since I saw you last. If anyone has any questions, I'll try to address them. If I can't, I'll follow up with you after the meeting.
Okay, anybody? Yes, Counselor Shaw?
I don't have a question, but I have an announcement, and that is now you don't need a FOIA job description. I was disappointed not to see your report, but no, Chief Hoskin has notified me that we no longer have to do a FOIA to request a job description, that they are now available. And I'm grateful for that.
Okay. We're needing a couple math teachers there at Sequoia, if you can help them out with that. We have our principal teaching 2 hours of class up there and does an outstanding job, but if you could help them expedite those openings, appreciate it.
Okay, I'll check on
Okay.
it.
Anybody else? Good report.
Thank you very much.
Okay. No old business pending. New business, Counselor Legg, you want to take the first one?
Resolution confirming the appointment of Crosby Connor.
Point of order, excuse me.
Yes.
That's the one I was going to withdraw.
That one there?
Yes.
Oh, okay.
Sorry.
I'll do B.
Okay. Okay, withdraw. Is that all we need to do, Shelley? Okay. All right, well, we'll let you have the number 2 then.
I was on it now. A resolution confirming the reappointment of Wayne Caldwell as governing board member of the Cherokee Nation Comprehensive Care Agency, PACE. I put that in form of a motion.
Got a motion and a second. Is Mr. Caldwell here? Okay. Any discussion? He does an outstanding job for us, been with us for a while. Okay. All in favor, signify by saying aye. Aye. All opposed? Okay. Any comments, Mr. Caldwell?
No, thank you for allowing me to serve in this.
Okay, appreciate you. Okay, number 3, Counselor No Fire. You want to explain that?
Yes, this is an act amending Title 10 of the Cherokee Nation Code of Antidote to preserve, protect, and incorporate certain tribal customs, traditions, customs, and culture. Just kind of a brief kind of idea behind what I was bringing up here. It's an amendment that was written with the intent to protect and preserve certain cultural customs and religious beliefs for our Cherokee children. And kind of what I'd like to do here is just open it up for discussion with the idea and the intent that we can table it in amongst the discussion till next meeting when we're talking about this. So that's kind of the motion I'd like to have carried out with your recommendation, Speaker.
Okay, if you want to get into discussion, then we're not going to ask for a table then, but as soon as you think we've got too lengthy, then we can table. So if you have a question or comment, council, committee, what's up? Councilor Lay?
So I've got a chance to kind of hear a little bit about this morning. I just want to, if we do anything on this, my deal would be the tiers. How to prioritize when we're going into a case, or if we're ruling on custody of a child. Went to college to be a social worker. The number one priority is family reunification above all. And if you have a biological mother and father, family reunification is most important. The thing what we have is dealing with clan systems. Our cultural side of this is how far do we go in protecting our culture as well.
Tim, you want to go ahead and, we may need to ask you a question. Go ahead, you're on a good line here.
Yeah, and so, we don't have hundreds of thousands of traditional Cherokees practicing their clan. We just don't. But I think that the ones that do, they hold it sacred. And this is kind of a tough situation to be in. But anyway, I want to hear more pros and cons on both sides, because right now I'm about 100% pro on this. I know that there's some there's a case, that really needs to be moved on quickly because it's about to go in front of the Supreme Court. But there's got to be some cons to this, because right now all I see is positive. And but again, I'm all about protecting our culture. We all swore to it. but I'm also about family reunification. And so there's a, I'm kind of torn.
Okay. Point well taken. Counselor Dare?
I was just going to bring Tim in and see about the legalities of this and his thoughts on this, since he got it wrote up. So.
Well, I just want to reassure everybody that this legislation is very narrowly tailored. It has a very specific intention, which is one is to recognize Cherokee elders and allow them to be able to testify in our tribal courts, to be able to allow the court, not require the court, but to allow the court to take those Cherokee elders and the knowledge that they can share as testimony and as evidence. We've been notified that there have been at least one instance where a Cherokee elder was excluded from providing testimony, which is essentially that's part of preserving our culture, is that we recognize that our Cherokee elders can provide that history and that tradition that our courts need to be aware of, which that is distinct and different from the European style of court system that the state of Oklahoma practices. And so I think that's the first. The second aspect of it is, like Darrell mentioned, is the clan system, which is a very small portion. For starters, you got to be able to prove that you're a member of a clan. I mean, there are many Cherokees that say, I'm Deer Clan, or I'm whatever clan, but you have to be able to go in court and prove that not only are you a member, but that you practice the clan system. And so that gets back to the very small number of traditionalists that practice that clan system. But there are those traditionalists out there, and we need to protect them and to acknowledge that we are a tribal government. We're not a state government. We're not a European government. We're a tribal government. We need to recognize that we do have traditions and cultures. And everything in these few changes, it allows the court to take this information into consideration before it makes a decision on a child. Doesn't require them. The only requirement that we did add was that the court shall appoint a GAL, which a GAL is guardian ad litem, and that is generally a person that is intended to look out for the best interest of the child and report back to the court. This is an officer of the court that is appointed. I've been informed that typically it is a volunteer from CASA, and this person doesn't represent the child, doesn't represent the parents, doesn't represent Indian Child Welfare. It's a neutral third party that can go out and investigate and come back to the court and say, this is what's going on, court, and this is what I think, based on my experience in dealing with children in these situations, is the best interest of this child. And it doesn't, and typically courts appoint these, but again, we've been notified of a situation where the court didn't. And, that creates the appearance that maybe, the court didn't do what was in the best interest of the child. Whenever a GAL is appointed, that's the sole role of that GAL. And so that's the only requirement that we are putting on our court system, is that they have to appoint a GAL, which, my experience as a prosecutor is always in the best interest of the child. It's not going to hurt anybody. My understanding is also that our GALs are volunteers. So the cost is negligible. In this instance, it puts that, the judge doesn't have the discretion to say, I don't feel like appointing a GAL in this case. But otherwise, it recognizes specifically that Cherokee elders should be respected, and they should be allowed to provide testimony on what are the cultures and traditions. Because I think that's one of those things that we talk about cultures and traditions all the time, but where do we get the information? And in a court system, you have to have evidence to support things. So specifically, testimony is one of the best ones, but how do you decide who is qualified? Cherokee courts, our judges have some history and have the ability to do that. There is language that Indian Child Welfare brought up that would allow Cherokee Nation to intervene if any state court tries to use this language against us. Cherokee Nation gets to intervene and decide who is a Cherokee elder. And so that was the one issue that was brought up by Indian Child Welfare, and we addressed it. It's our understanding that there are no other issues other than potentially the AG's office has not fully, I guess, given us their blessing. So I think that's up to the council to decide, do we need the AG's office to approve legislation before the legislation is considered, or is it within our authority to go ahead and make our own legislation?
We've done it both ways.
Absolutely. I'm just
Yes.
saying whether or not we need the AG to approve our legislation before we can take action on it.
Again, we have done those both ways. Sometimes our legislation is not that questionable.
Right.
But sometimes, what we're very careful on is the reason I usually ask the Attorney General's office is I don't want to pass legislation that may contradict something we already have in place. And so anyway, let's keep going here. Councilor Shambaugh?
I think that's, would be my question, is, was the AG's office approached about this? And personally, as a tribal councilman, I do want to know what the AG's office thinks. That necessarily doesn't tell me what I'm going to do, but it's also going to help me make an informed decision. And if there are things that could be raised, let's say we have things in place that this will affect negatively, I mean, I want to know about those things. I mean, obviously, if there's not, if there's some, maybe some reluctance in part of it, I want to know what part of it and why. Because if there is something that will affect what we have going in a negative manner and work counterproductive to what we've already doing, I mean, that's the whole point of fixing it before we vote on it. You know, I just think that's, if there are those concerns, then they need to be fixed. Yes, I think this is a good thing. I really do. But again, I think we need to sit down with the agencies or the department heads who are, you know, where we get information from so we can make the best informed decision and we don't do something counterproductive to maybe something that we already have in place. That would be my only.
And I agree with you 100%. I mean, it's one of those things that is the process that we went through. As legal counsel for the council, I looked at the other portions of our code. I didn't find anything that this is going to interfere with or contradict. Like I said, it is very narrowly tailored. The only requirement is on the GAL, but specifically, you know, Councilmember No Fire reached out to Indian Child Welfare, and we got feedback from Indian Child Welfare that they were concerned about this, and we went in and we tried to fix that. You know, we were under the impression that if Indian Child Welfare wanted the AG to look at it, that they would have presented it to them. I believe that maybe that ball got dropped, that maybe Indian Child Welfare didn't realize that that was their obligation as part of the executive branch, that for the legislative branch to go to the executive branch and ask them to review something is really an issue with separation of powers. You know, you can look all around that the Attorney General, Mike Hunter, does not review legislation before the state takes it up. They have their own attorneys, just like the council has its own attorneys.
I understand that, and you know, if we're going to talk about if Indian Child Welfare has some questions and some issues, and those aren't, or those haven't been addressed, is that? I mean, you're
No, we address those specifically.
I mean, but so everybody's in Indian Child Welfare is in agreement with
That's our understanding.
Okay.
Is that they had one issue, and it was easily fixed, and that was specifically to allow Cherokee Nation to intervene in any state court that tries to go in and allow some random person to say that they're a Cherokee elder.
Okay.
So one just real quick last thing. So I know the AG's office, but basically doesn't tell us what to do. But you know, it is a form of information. Would they give a input on this today?
I have no issues with you know, if the AG wants, if the council would ask for input from the AG's office, I think that's appropriate, and I think that's the process. Is if the council solicits advice or counsel from the AG, I think that's the process.
Okay. let's have some more discussion here. Are you through?
Yeah, if Indian Child Welfare is good with it, I mean, I kind of would like to heard from Indian Child Welfare to tell me that they're good with it. I mean, that's all I need to hear.
Okay. Counselor Critton?
Yeah, first of all, I think you done a real good job today. And Councilor No Fire, and I've been making some calls and visiting. The gist I got out of it is, you know, like you said, secondarily, some of the culture aspects, but you can't say secondarily because our elders, our culture, whether they go by, you know, whatever belief they go by, elders are our culture. And the gist I get from this is we're giving elders, among other people, a voice that sometimes the court don't allow. And then I said, well, who makes the decision of who's an eligible witness? Who's a good elder to go do that? Cherokee Nation. ICW is what I understand. You know, someone in Cherokee Nation, we're not just going to throw every elder that wants to speak. We're just allowing them a voice. Plus, we've got someone policing that, saying, yeah, am I on the right track here?
Right.
And and I understand what people are saying, but I don't ever want to get away from, you know, we have a council attorney, and we are a branch of government, and I'm nobody's saying different, but I don't ever even want to get close to getting away from us. You know, we're pretty sharp folks, putting something together to lay out at this council meeting, check it with our council attorney, and hopefully people work together. But there's going to be some times that, you know, we don't have to work together. Here's council's legislation, our attorney general, or not attorney general, but our attorney, who, you don't do this for free, do you? We're paying. That's a job title. So I never want to teeter on asking somebody's opinion. Now, working together later on, but I like it just fine when this body comes up with something and it's legal. And boy, I hope you like this, everybody. Then you can give us your opinion. That's the way I believed from day one, and I just want to get that out there. I don't want to toy with that other direction. So, thank you.
Okay. Anybody else? Yeah, Counselor Coates.
Thank you. Mr. Brown, can you explain, your comment during your explanation was that there would need to be proving of a clan, that a clan was existing in this particular instance, and how would that be done, and et cetera, et cetera. Can you?
It wouldn't be that a clan exists, it'd be that you actively are a member of the clan. And so that would be done through the legal process. And the legal process is simple. You present evidence to the judge, and then the judge determines whether or not that is something he's willing to consider. And again, everything in here is that the judge may consider it. And the word may is different than the word shall. And so everything in here as far as elders' testimony, the judge may consider. And this is all to open it up to allow the judge to make the best decision for the child. You know, ultimately, you know, we operate in Indian child welfare on what's in the best interest of the child. But as a tribal entity, we also recognize and honor our traditions and cultures, which are not always the same as the European traditions and cultures, which is specifically what led to the Indian Child Welfare Act, was that families were raising kids outside of what the European government felt was the immediate family. And Cherokee Nation has historically, you know, especially the traditionalists, allowed those things. So
I understand all of this. The thing I think I'm thinking about in my head, and the questions that I have are along the lines that, first of all, it's my understanding that we have gone through eras, and that there are probably still people existing who are reluctant to share information about their clans with outsiders.
Correct.
So that's one one consideration. The second thing is that there are people who may not know what the Klan is, but it's easy to tell just from a genealogical perspective that there is a Klan still in existence in that individual and within that individual's family, even though they may not know what it is. So are we going to make a difference between those who know what it is and who are living by it and who are practicing within that system versus those who in fact are members of clans, you know, still, and even though they may not be practicing, even though they may not be cognizant of it, and what kind of dilemma does that present to us from a legal perspective? Are we, you know, is there a discriminatory situation in that event?
And again, I think that there's no situation that a judge can't address. And ultimately, it's always going to come down to the discretion of the judge. All this does is allow the judge to consider a Klan. You know, if you have the uncle of a mother taking care of a child, historically, you know, and you're a traditionalist, historically that's okay. Whereas if you are within the European system, they look at that negatively. They're like, well, why? Where's the father at? Where are these other things at? But again, it's the court may. The court does not have to decide that this is okay. This is what's best for the child. It just allows the court to acknowledge and respect our traditions and cultures. If the court looks at a specific situation, it can make a determination based off of the facts in that situation. You know, one of the conversations that I did have with the Attorney General was, we're not legislating to a specific instance, to a specific situation. I tried to leave this very narrowly tailored to allow the court a lot of room in making its determination.
And I want you to understand, I'm not challenging this. I think it's a great idea. What I'm trying to think about is what kinds of ways it might possibly be abused. And,
absolutely.
You know, I guess that's just to clarify. I think that's more the gist of
absolutely. And any questions that you have or critiques, or you know, when you start trying to poke holes in any legislation that we come up with, it makes it stronger. And so I'm never going to be adverse to any questions that you may have. As I'm trying to help the council members draft legislation, I'm trying to think of the same legal issues that could potentially create problems. And like I said, I've practiced in tribal court with Indian child welfare with these kids, so I have actually practical knowledge to how things can blow up and things can go sideways. So again, that was why I tried to make this very narrowly tailored to only allow for Cherokee elders to come in and provide, testimony. And in order for you to, if you don't have any, and here's part of the, let me explain part of the reason. If you don't have direct knowledge of a situation, typically a court will not allow you to come testify unless you're an expert. And in that case, you can come in and you can give opinion testimony. You can give all these things based off of stuff that you don't have direct knowledge of this child or of this situation, but you have knowledge of this community and how this family works. But you never saw what happened in the home, but you can come in and say this family practices the Klan system, and that that they you understand what I'm saying. So I mean that's the intent.
When I was teaching the Cherokee Nation history course like almost 15 years ago at this point, and I taught it for employees, and I would have ICW workers who would come through it, and we always did probably a couple of hours just talking about Klan systems alone and how they worked in the past and in the present, and it was one of the most rewarding sorts of comments that I ever got back from ICW workers in particular, that they felt that they had been armed in a way that they could go into court now and argue on behalf of some of the traditional families. So that was at that time, I think, the notion of not coming out of of kind of an institutional or academic setting with that knowledge, but of that knowledge coming from elders and traditionalists is even more powerful. So I really
Absolutely.
think this is
And that's the intent. That's all it is. It's just basically to expand upon the knowledge base that you have instilled in these Indian child welfare workers to the experts, to our traditionalists, our Cherokee elders, that they know this better than anybody. And so you can't get a better source. I think, what has happened is that sometimes, how do you determine who should be able to come in and give expert testimony?
Sure.
And in this situation specifically, this is what we're doing. We want our courts to be able to hear from our elders, and that was what the purpose was.
Okay.
Okay.
That's it.
We have Counselor Deere.
Just real quick, 2 minutes. I mean, we did take an oath to protect our culture, was one of the things just directly out there.
Sure.
Some of us that are part of a clan, Speaker knows my family's pretty huge, and I am part of the Wolf clan. When we talk about things like this, when you go somewhere and somebody pretends to be part of something, in our culture, we don't let that happen, and we take care of that within ourselves. So if it was to ever go to the court system, the elders would stop that before it happened. Does that make sense? That's just the way that culture works, because you can identify in your family, you're like, no, he's not. No, she's not. And I just wanted to state that. I think it's a good thing to protect that part of the culture. That's why we took that oath. That's why we are. And the clan people will identify that and take care of that amongst themselves before it gets to that point. And I don't think anybody in their right mind would go to testify in court and pretend to be part of something they're not. And that's all I wanted to say. I think it's a good thing, Wes. So.
And if they do, you have a Cherokee elder that can come in and say, no, they're not.
Right, and they'll smash that pretty quick. So that's all I had. Thank you.
Mm-hmm. Yeah, it's kind of like when we did our speakers, you had to have 2 witnesses. So you could say you were a speaker, well, you got 2 elders sitting there, say, well, speak, and we'll have 2 elders here say, pretty quick, it takes 30 seconds. You either are or you're not. Counselor Jordan.
I'd like to get opinion from the AG's office on this, from Chrissy.
We want input, not an opinion.
I want an opinion.
Well, I thought that we offered our input. First, I want to say that I absolutely agree that the AG's office in no way has to bless anything that this council does. I had a 20-plus minute conversation with Mr. Brown yesterday. I do have concerns about this legislation. I don't have general concerns about incorporating cultural knowledge into child welfare proceedings. I think our law already does that. The first preferred expert witness in a juvenile case is someone who is knowledgeable about the traditional and cultural child rearing practices of the tribe by law. I am more constrained in talking about specifics of a case, but in the case we're talking about, the person attempting to testify was allowed to testify. The only time in a juvenile case that you have an expert witness is when the nation has to prove that continued custody would likely result in serious physical or emotional harm to a child. In the case we're talking about, a child is returned to a parent. So we can talk about all of the culture and tradition and everything else we want, but that never puts a non-parent above a parent in placement. The goal of juvenile cases is to reunite children with their parents, and that's what happened in this case, and someone didn't like the result of it. And I'm frustrated that we're talking about something that is different than what happened, and that we're assuming.
But this legislation has nothing to do with what you're talking about.
This is not really for a specific case.
It's not written for a specific case. It has no effect on the placement
Point
order.
of order, may she continue without being interrupted.
So with that, I have expressed several concerns. It also, as written, doesn't apply to guardianships because that's Title 30 in the code. The placement preferences, as written for the clan system, doesn't apply in foster care or adoption because that's contained in the ICWA placement preferences in a different section of the code. These are conversations that I would have liked to have with Mr. Brown individually or with Wes, who I told Mr. Brown yesterday that I would like to meet with him and Wes to talk through this. Again, not because I have to bless anything that this council does, but it is something that our office is intimately involved in. We prosecute these cases in tribal court and in state court on behalf of the nation. And my ask was that it be tabled today so we could have this discussion offline, so we could offer our comments for Counselor No Fire to do with, what he chose. And so it was not that we hadn't blessed it, that the objections, there were technical legal objections to how things are written and where they were put into a code that can have serious effects on the cases that we try every day. The specific case in question has been appealed, but I want to reiterate, I am always going to err on the side of the first goal of juvenile cases is parent reunification, and everything else comes secondary to that, because no other person, regardless of their religion or culture or anything else, gets to step in front of a parent to take custody. That is our goal in tribal court, that is our goal in state court, that is what ICWA is primarily designed to protect, is the parent-child relationship, and everything comes second. And again, I'm a little bit frustrated about this because I didn't get to have this conversation in a way that was productive and sit down and let's work through some of these problems.
But but it's okay. I mean, this is a good discussion. We don't need to be upset about it. We're trying to take care of cases that may take place again. And you're referring to a specific case that it may affect, and that's what we wanted to hear, and that's what Counselor Shambaugh, brought up
It won't
earlier.
affect a case because laws don't apply retroactively by Constitution in the Cherokee Nation, so anything we pass has no bearing on a case that's already happened.
Okay, so then there shouldn't be much frustration then. So anyway, back to the input that we have here today. Counselor No Fire was willing to discuss it. If it got too lengthy, then he said, then I'm willing to table and get back with the AG's office and make sure we amend or take care of any wording that may affect the current legislation we have in place. So that's where we are here. To me, it's been a good discussion, have
A great
input from
discussion.
everybody, because traditional people, I'm very well aware of. Well, a lot of times we don't go tell what our cleanse is in the first place. If somebody asks me, you have to maybe hypnotize me. That's just the way we're raised. But if we have to go to a court in front of a judge, then maybe we might divulge what that is. So back to what I'd like to recommend is a lot of discussion here today. Why don't we have Wes and Tim get with the Attorney General's office, see if there's some wording in there that we need to look at and bring it back next month. How's that? Is that okay with committee? Is that okay?
Yes, absolutely.
Because we've had good discussion
Yeah,
here,
absolutely.
and I like that. I mean, no
Yeah.
one needs to be upset.
And that's what I wanted to do, is I wanted to hear
Yes.
everybody's input. I think it's a great idea, and a lot of you, I think, feel the same way. It's just we kind of got to make sure that we're doing everything that's necessary to protect
Protect and yet stay in compliance.
Yes, and staying in
Okay,
compliance.
is that good, Tim? Any questions?
I'm here to serve, so.
Okay. All right, I need a motion to table.
Make a motion.
Make it,
Second.
yeah. Just making sure that we're making a motion to table it till next
Yeah.
rules meeting. Okay.
Got a motion and second. All in favor, signify by saying aye.
Aye.
All opposed?
Aye.
Okay. Good? Thank you. All right. Counselor Austin, the next one.
Sure. This is discussion only, it says, which I think that's because it's policy, it's not legislation. And in the 4 years plus a few months I've been on council, we've had the sports funding program, and it's been set at 51% of the participants must be Cherokee, and then that program has been funded. There's always been funds left over at the end of the budget year that I've seen. We apparently were having a hard time finding enough teams with 51% Cherokee. And I know up in my district, I've been able to find 2 teams in that entire time, which the entire first 4 years was 1 team. I just was able to locate another team that had 51%. I don't remember ever seeing one from Washington County or Nowata County or Tulsa County that was able to find 51%. But there's a lot of teams that we can get 25%. And what I would like to propose is that we change that policy so we're at the 25% threshold, then they would receive half the funding they would at the 50% threshold. So that-
Jody, you want to step up? You and Gail, probably both of you. How long has this policy been in place?
Cherokee first had it before us, and that was their requirement too. And then we took it over from Cherokee First. Because it's tribal funds, they have to be 51% Cherokee.
We have had money left over the last few years because, about 3 years ago, we actually run out,
We
and
ran
I've
out.
started putting more money in this program
Yeah,
too.
So it's not had money left over every year. We've gradually added every year.
Yeah.
Okay. I don't have any problem in Cherokee County.
Mm-mm.
I mean, I have to sometimes say, I have to take it out of my community funds if I'm going to fund some, and it's $500, right?
Yes.
So if I get in a bind, I'll just take it out of my community funds.
Mhm. And
Or- or
that's
you-
what was done, why we ticked it over, it was, you guys were funding these ball teams with your community funds. So Cherokee First turned it over to us, that way we could do, all those teams that were asking money for y'all we would sponsor them out of this sports funding, and it wouldn't take away from your community funds.
How do we hold these people to 51%? Who
They
does
fill out
all of
a-
that?
They fill out a roster, and they fill out their whole roster, and they mark the ones that are tribal members. And so and then they also attach a blue card. And registration gives us, we have access to just checking out their card, see if they're truly members. Because some of them have relinquished, but they'll still try to use their blue card to get, that's just how some of them are. But we verify them, and we can verify that they're 51%.
Okay, well, good, at least we,
And for the most part, there's not a whole lot that we turn away, but there are some that do not meet 51%.
Counselor Buzzer?
Yes, I just, and I don't know if I'm for or against this right now, but I've had teams that's had 49% and I didn't get funded. If you look at the voting people that, in my district, people that register to vote in his district, Joe Deere's district, what's the numbers? You know, those numbers are higher than probably my district. So I don't have any problem with it, but they have more people that are registered to vote than I do, so I don't really see a big problem with it. I know I've turned in cards and we only had 48%. I didn't get funded, so that's kind of where I'm coming
And
from.
we have, how many funds do we have that we could fund somebody that needed $500, Jody?
Special projects.
We've increased it, people.
You can fund
It just
them out of
depends on
other
how you're
projects.
going to manage your funds. I mean, there's very few requests that come through me
The
that.
question,
Go ahead.
sorry. One of the questions that was asked was what was the anticipated amount that would require, and we really don't know because most people, of course, know the policy and they're not going to apply unless they're close
Yeah.
to that 51%. So there's really no way of knowing how many teams are out there that would qualify for the 25%. I'm guessing it would there's probably going to be twice that many teams
Yeah.
that what get funded now, so you're probably talking about the same
We
dollar
trying to fund
amount.
tribal teams, or we just trying to fund teams that has an Indian on there?
Yeah, so.
Yeah, because my deal is you got a team that has 12 people and one of them's Cherokee, well, all the other ones are gonna benefit from the money too, and they're not Cherokee.
But that is not what is proposed here.
It's,
Counselor Critton.
yeah, that's what happens though.
I was just gonna say, I know where this idea is coming from. It's a great idea, but we gotta get the money ready, because like in my district, in Canaan's district, there's a lot of teams already. Now you add this 25% deal, you're gonna get our teams that already do it. That's a whole new slew. But I like this idea, and I'm planning on helping you out today. But I'm just saying, we better get that money ready. Thank you.
Okay, Counselor Coates?
I'm concerned that we have the slippery slope here because this is one thing and virtually everything in our nation requires a 51% Cherokee, whether it's Taro, whether it's grants for community assistance, community organizations. I mean, just across the board, this is the standard. And I think if we start chipping away at that, you know, it sets a justification for other programs to say, well, they do it, you know, why are we being held to some kind of a higher standard, you know? We've just reduced the at-large community organizations were being held to a higher standard than those in the jurisdiction. And it was, you know, it was something that was recently equalized, but it's still at a majority. If we drop down below this, I could foresee, are we going to drop down below, you know, the 51% requirement for the at-large organizations and their membership? Are we going to say that, you know, community organizations within the boundary don't have to have 51% before CATA will fund them? You know, I mean, there's a lot of things that I think could potentially, you know, slide off of this in a way that I think we need to be concerned about, because I don't think we need to be, you know, supporting everything in the world because there are 2 Cherokees on it, you know? And I don't know, that's my
Good
sense
point,
about
well
it.
taken.
Yeah.
Councilor Sambo.
It's difficult. I mean, that's probably the best argument I've heard. And, you know, if you're going to think outside the box and how to try to get more people involved, but at the same time, again, you have to look at what it's going to do to our other programs. And I just think that's kind of mirrors what our last deal. I mean, you know, getting on the same page and not hurting what we already have is the main goal. I personally, I think I'm a big sports guy. I am, but this is Cherokee Nation, and you know, I would have to stay with the 51%. I mean, I know it would be a good thing, but again, I think what Councilwoman Coates said is something that really, it's hard to get by that. I mean, because if you set a precedent in something, then, you know, it's going to come back and say, well, you did this before, and they're going to want to do this for everything, or, you know, it could possibly turn out that way. So this is tough. I mean, it is, but I think that with that argument, I think it would have far-reaching effects on other things. So I think I would probably have to stick with the 51% personally.
Okay. Councilor Vasquez.
Yes, I just had a comment that Gail brought up a very good point. We have lots of different ways of funding things, and we have lots of budgets to operate with. So I don't think that's an issue. Sorry.
There's the, what's it called, the youth grant?
Yeah, community youth grant.
For individuals
Well-
that don't qualify, or actually they could qualify for the team and still get it if they do community
I
service.
have participated in Little League. I used to run the Little League program here in Cherokee County, coached it all the way up. I would not want to prevent any of our tribal members not playing on a team. So if there's teams that are not able to get funded, Councilor Austin, we will do whatever we can to make sure they're funded. But I do like the policy because look at the money we give from our sales of our car tags without any holes there. We just ask discretionary money that we give to the schools right now. And if there's 75% non-tribal members on that team, surely they can come up with a fundraiser and come up with $400 or $500. I was at a non-tribal, one of my nephews is on a ball team. He's the only Native American on the team. I spent all weekend down there buying cakes and buying shirts that I can't use. But that's part of Little League. It's people coming together and help and do fundraiser. That's what bonds everybody. That's what Little League's all about. We as Cherokee people have spoiled our constituents because when there's a need, we're supposed to take care of everything. But I would not want to keep any Native American, any of our people not participate in sports. So there's a way to help fund those, Counselor Austin, and you're doing your job. You're here advocating for your district, and that's what we're supposed to do. But we don't want to keep anybody from your area not playing Little League ball. So having said that, I support the current policy we have in place. Anyway, it was just for discussion today, and it was a good discussion. If you don't have any more comments, we'll move on to the next item. Okay. All right, announcements. You got a meeting tomorrow night?
6 o'clock.
Okay. I need a motion to, second, I'm a motion, second, Augie Yosef.